Thousands of protesters marching in Alabama to protest the most restrictive anti-abortion law in the country, joining a total of 8 states that passed such laws just this year alone. Now, their Republican sponsors say their explicit goal is to put these abortion bans before the Supreme Court to narrow or end Roe v. Wade. This is about abortion and women's rights, but it's also obviously about politics. Take a look at Politico reporting that Trump's campaign team thinks his re-election could turn on the courts, while Democratic candidates vow to protect Roe.
They're trying to overturn Roe versus Wade. That's wrong, and we will fight back.
The idea that women in this country should not be able to control their own bodies is beyond belief. They have that constitutional right.
Women's access to reproductive health care is under attack, and we will not stand for it.
So how does the U.S. Supreme Court approach bills that are designed to draw the court into election year controversies? Can the justices find a way to punt if the lower courts are actually putting pressure on them to act? Well, we turn now to an expert on these matters. With me for an edition of Opening Arguments is former Solicitor General Neil Katyal. He's argued dozens of cases before the Supreme Court as a private attorney, as well as President Obama's acting Solicitor General. Good day to you.
Good day to you. I've missed you, Ari.
Well, we miss each other. When you look at what's happening here, explain to us, what does the Supreme Court do when it balances its obligation to obviously deal with certain cases, particularly if they have to resolve something from the lower courts, but also something you've taught us about before, which is that Chief Justice Roberts and other members of the court are keenly aware of the risk of being drawn into election year controversies by politicians.
Yeah, so it's often said that the Supreme Court and American law in general is built on the idea of precedent. It goes by the Latin phrase stare decisis. And the notion here is that basically the Supreme Court follows what predecessor courts have done. It's kind of a Burkean notion of like there's wisdom in how our past generations have dealt with something or past decisions. And so they're really reluctant to overrule things. Sometimes they will, but they will so only rarely. So I think the best example of this is Roe versus Wade. I think many people think wasn't the best executed decision in terms of its legal reasoning, but the Supreme Court in 1992, in an opinion joined by 3 Republican appointees, Reagan appointees and Bush appointees, Justices Kennedy, Souter, and O'Connor, all said Roe versus Wade, the precedent behind it, should be upheld. And so even if we have some problems with the decision, social expectations have crystallized around Roe versus Wade, and it would destroy the court's legitimacy to overrule it. And so that's the general way the court approaches these things, which is to say we follow our past precedent. This court, there's a question about that, though, a big question mark. Are they going to do it?
You saw Justice Breyer make some comments through a ruling that were quite restrained and broad, but he says it's dangerous to overrule a decision only because 5 members of a later court come to agree with the earlier dissenters on a difficult legal question. And then he says today's decision can only cause one to wonder which cases the court will overrule next. What do you view as the significance of that?
Huge significance. So that case itself was about a relatively minor issue, nothing like abortion. This is the Franchise Tax Board case the court decided last week. But Justice Breyer, who's a very, very moderate justice, was signaling his concern that the more conservative members of the court are not going to follow this rule of precedent, not going to follow stare decisis. And, you know, the #1 example of where the rubber meets the road is abortion. Are they going to follow that 1992 decision or not? And what's going on in Alabama, it's all about literally this, Ari. So, I mean, the Alabama legislators are saying, we think the conservatives on the Supreme Court will overturn Roe versus Wade. And, of course, President Trump promised to only put justices on who are pro-life justices.
Let me ask you, do you think, and this is where the public politics and strategy meet the law, do you think that was smart of them, or does that actually make it harder for some of the votes they would need to get on the court?
Right. I mean, so Thurgood Marshall really pioneered modern Supreme Court litigation by saying, look, I have this ultimate goal, desegregation of our society, but I can't just go in and do it all at once. If I go in and do it all at once, the courts aren't going to buy it. And here, Alabama has tried to go in and do it all at once. I mean, this is a very extreme bill. It bans abortion at any stage, including for rape and incest. So it doesn't even meet the Ronald Reagan test for an abortion law. So I do think that there's a risk that if this was the case that went up, the Supreme Court could say, well, that goes too far, and leave for another day the question of whether Roe versus Wade will be overturned. But, make no mistake, there are these laws in other states that are being considered,
Right.
these so-called heartbeat laws in Georgia and other places, and all of them are the more moderate strategy: get a case to the Supreme Court after the election, not before, and that they think they have the votes to overturn Roe versus Wade. And there's certainly a possibility that that is going to come to fruition,
Right.
absent a change in the composition of the U.S. Supreme Court.
I also want to
That's
get you
what the meaning of the Kavanaugh thing was about last year.
I also want to get you on some constitutional fireworks. A Republican Congressman Amash saying that what Trump did is impeachable. Brand new response from the president. Take a look.
He's been against Trump from the beginning. He probably wants to run for some other office. I don't think he'll do very well. He's been a loser for a long time. Rarely votes for Republicans. And, personally, I think he's not much.
Not a very substantive response to what Amash said. I wonder if you agree with his points that the underlying conduct would be indictable if anyone else did it.
Yeah, so I've been at the Yale Law commencement, so I haven't seen that clip, but I think that
Brand new.
basically, yeah, so I think that, you can just tell from Trump, there's no legal reasoning in there whatsoever. And by contrast, there's now been a letter signed by almost 1,000 former federal prosecutors, and there aren't that many former federal prosecutors around. They're not, that's a small number in general, and 1,000 is a very large number of people coming forward and saying this would be indicted if it were anyone but the president. So this whole idea, the president says the Mueller report clears him and this and that, is, to use the technical legal term, poppycock. And if the president thinks this is right, that he's been cleared, fine. Let's have a trial and let's prove it up the way it would be for you or me if I were accused of these obstruction of justice crimes.
Neil Katyal, always great to get your insights. Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.